Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. David Schwartz, the Chief Technical Officer of Ripple, has changed his Twitter profile image to a photo with a message. The context and the term Ripple at the top indicate that it refers to the SEC's action against Ripple. Members in the crypto world are speculating on what Schwartz may imply and if there are any indications on the case's conclusion. When a scrappy financial startup takes on a web of corruption and betrayal to bring instant payments to the masses, they learn that the cost of disrupting the status quo is higher than they could have imagined, forcing them to choose between their vision and their survival, says the message on the profile picture. Several crypto aficionados on Twitter have reposted and commented on screenshots of this message, as they attempt to figure out what the C2 of Ripple and co-creator of XRP Ledger possibly mean. They do, however, agree that this is most likely a legal battle with the U.S. Securities and Exchange Commission, which has been ongoing since late December 2020. Many members of the XRP army started tweeting their support for Schwartz, EO Brad Garlinghouse, and other Ripple executives who are working with the legal team to win the lawsuit and preserve the crypto sector from SIA control. As many crypto fans think, the SEC seems to be attempting to declare digital assets as securities and regulate them using securities law going back to the very analog early 20th century. The Twitter account Ashley Prosperone thought that the objective of Schwartz's tweet is that Ripple may have to sacrifice their goal for the firm in order to exist as a corporation, i.e. just persuade the SEC to recognize XRP as a non-security, as Bitcoin and Ethereum do. John Deaton, the creator of CryptoLaw, U.S. and an outspoken defender of Ripple against the SEC, has revealed what he thinks is the primary condition on which the fintech startup will agree to settle with the SEC. According to his latest Twitter thread, this is if the SEC signs a document stating that XRP is not a security, including current and future sales, as well as secondary market archer sales by any person or company such as cryptocurrency exchanges. He feels that 1010 attorneys advise settlement in this matter. Deaton believes Ripple would refuse to compromise because it would battle for all of cryptocurrency. He believes Ripple will have to settle because it serves as a fiduciary to its owners. Ripple would be in litigation for a decade if they turned down a chance to settle the case and lost. Despite both parties in the Ripple and Securities Exchange Commission (SEC) case making final submissions and awaiting summary judgment, the main focus still lingers around the regulator's power in providing oversight in crypto alongside unsealing vital documents. Under the latest update, pro-XRP lawyer John Deaton has questioned a statement by SEC Chair Gary Gensler alleging that any crypto besides Bitcoin, DC, is classified as a security. It is worth noting that the SEC is using Ripple for selling XRP as a security. In a tweet on February 27, Deaton stated that there is no consensus regarding securities classification. He made the remarks in reaction to a comment by MicroStrategy Executive Chairman Michael Saylor, who noted that Gensler's remarks are testimony that consensus is building on the classification of security. Previously, Deaton shared the possible arrangements for both parties to settle even as they await the summary judgment. According to Deaton, Ripple would pay $150 million in a settlement if the regulator agrees that ongoing and future sales of XRP are not classified as security. However, he cautioned that the likelihood of the SEC agreeing to the approach was minimal, considering the agency's increased crackdown on the digital asset space. Deaton pointed out that the presiding judge could clarify XRP's secondary sales in this case. It is worth noting that Ripple General Counsel Stuart Alderoty had earlier insinuated that the SEC has minimal chances of winning the case at the Supreme Court based on historical outcomes. The SEC has lost 4 of its last 5 cases in the Supreme Court, thanks to the few that had the courage and resources to fight back against the SEC's bullying and clinging to stretch legal positions that were not faithful to the law, he said. As previously reported, the case received new rejuvenation after a journalist, Rosalind Layton, filed a motion to gain access to the Hinman speech documents. The speech was issued by the former director of the SEC's Division of Corporation Finance in June 2018 and could offer a clear representation of how the SEC classifies securities. Hinman noted that Ethereum, ETH and Bitcoin are not securities, and the same approach could be applied to XRP. Elsewhere, defense lawyer James Fallon also revealed a new development in another long-running legal battle where Ripple has been facing a class action since 2018. In the matter filed in California, XRP investors sued the company and its CEO, Brad Garlinghouse, for selling XRP as an unregistered security and are seeking damages for the losses they suffered. They are requesting that the court declare XRP a security. As reported by Feinbold, Deaton had filed a motion to join the matter as an amicus brief. In the latest update, the plaintiffs filed another motion opposing Deaton's prayer to be included in the matter. The legal dispute between Ripple Labs and the Securities and Exchange Commission, SEC, in the United States is largely regarded as the most significant precedent for the cryptocurrency sector. If SEC Chairman Gary Gensler and his agency win the lawsuit, the crypto market should anticipate the U.S. government to come down even harder. Nonetheless, the motivations might be exceedingly dubious. In July, Cryptolaw, a website founded by attorney John E. Deaton, disclosed shocking information about Gary Gensler. Using the so-called Gensler files, Deaton demonstrated that the SEC's chairman may be operating in the best interests of others. At the time, it was revealed that Gensler had more than $100 million in assets and funds handled mostly by Vanguard Group through two important companies, Annabelle Lee, LC, and Marital Trust. Although there are no major meetings with crypto-related firms on Gensler's public agenda, he does have at least 7 meetings with Vanguard Group, and that conflict of interest is still present. At a time when not just Ripple is fighting the SEC, but the whole sector is facing Operation Choke Point 2.0, Gensler's preference for Wall Street titans is clearer than ever. Eleanor Terrett of Fox Business reported yesterday that the September issue of Gary Gensler's public calendar was published to the SEC's website. Highlights include 4 talks with CFTC Chairman Rostin Behnam, 2 sessions with former SEC General Counsel John Coates, and meetings with Vanguard, China's Ambassador Nicholas Burns, and BlackRock. It's worth noting that Vanguard Group controls Gensler's own wealth of $100 million, and he has allowed them unrestricted access to his office since becoming SEC chair, Deaton said. Deaton recently speculated on why the SEC is targeting Ripple and the broader crypto business. According to the attorney, Gensler will continue to regulate via enforcement until Wall Street titans like his Vanguard are happy. According to Deaton, Wall Street titans are typically positive about cryptocurrency. The CEO of BlackRock, the world's biggest asset manager, Larry Fink, has said that technology will play a huge role in the contemporary world. Moreover, he underlined the need of acceptable crypto rule. Deaton's findings were as follows. Ripple may therefore set a precedent for the SEC to regulate cryptocurrencies, allowing the U.S. agency to obtain jurisdiction over all tokens, ideally encompassing all secondary market transactions. In light of Deaton's discoveries, success for Ripple against the SEC becomes more vital than ever.